Our first session deals with managing disputes in growing markets, which is probably a nicer word than emerging markets, and has a more positive tone under it. I think what we will hear, and from the presentations that I've seen so far, we get both perspectives. First of all, the perspectives of arbitrators and mediators dealing with these type of disputes where businesses tend to avoid state courts and seek for a settlement in their disputes via arbitration. And at the end, from both Dalila and Tommaso, we will get the in-house perspective from a big international financial institution and from a technology company from Colt. But first of all, I would like to introduce Wolf von Kumberg. It's a very nice German name. I understand, however, that Wolf is American, Canadian, which is yes. I think nowadays you're right, Wolf. It makes a difference as far as I from both perspectives, and I understand Wolf's background has been years both in-house counsel and general counsel until he then moved into arbitration and mediation, director of the American Arbitration Association, the AAA, based in New York. However, Wolf, I understand, is based in London and will share with us his perspective based on many years of experience. Wolf, please go ahead.
As I was introduced, I was the European and Asian director for Northrop Grumman for almost 30 years, their legal director. So I was involved in all of our international disputes. And what I'd really like to talk to you a bit about today is the effective management of disputes. It's the AAA, thank you very much, is an organization clearly that was originally founded as an arbitration institution. The ICDR is its international arm. I don't know how many of you have actually heard about the ICDR. You probably heard about the AAA. But over the last, certainly decade, the AAA has been much more interested in how to manage disputes and, in fact, how to avoid disputes. And so what I'd like to talk to you a little bit about today, and really from my background as a general counsel as well, is how disputes in business, and particularly doing business in foreign jurisdictions where you might not be very familiar with the culture, you might not be familiar with the legal system, you might not be familiar with the way business is actually done in those jurisdictions. It creates an extremely high risk for any company that is doing that kind of investment. So what we have to recognize, if we could go on, as we know, if we're from business, I don't know how many of you are actually in businesses. Are most of you in business? Okay. So yeah, most businesses have business processes which they use to deal with the various risks that the business could potentially face. But one of the things that is actually not recognized to the extent that it should be recognized is that disputes, particularly commercial disputes, in a business will occur. We all enter into, I think, contracts with a lot of optimism and we feel that the contract will be completed without any problems. When I talk to programs people who were actually implementing contracts, they were always very optimistic, and there isn't really a proper recognition often, and certainly not a formal recognition within the business with respect to the dispute that might arise, and ensuring that there are processes in place to deal with those disputes when they arise. I don't know how many of you have dealt with the contracts group when they're actually negotiating a contract. It's very unusual for the disputes clause, for example, to be the key factor in those negotiations. Often the disputes clause is the very last thing that is put into a contract. It's usually a standard form disputes clause that has been used over and over again without any real thought being given to whether that disputes clause is appropriate for that particular situation and for the particular risks that might arise in that particular contractual situation. So I think what we're trying to say here is that there has to be some thought, some forethought given to the risks that might arise in a particular commercial situation, and how one then deals with those risks. Okay, I think we can go on to the next slide. So if we define risk as it's defined there, that it's a possibility that an adverse event will occur, and that the risk factors are the circumstances that will increase the likelihood of an adverse event occurring, then really what we have to do is try to identify the risk areas in a particular contractual context at an early stage. As we're looking at the other risk factors, for example, the financial risk factors in a particular commercial context, we should also be looking at the potential dispute risk factors, and then to evaluate the significance of particular risk factors in evaluating that risk. So if we're looking at a standard type of commercial situation, these are some of the risk factors that we feel should be considered. Certainly, the contracts and program management processes within the company have to be looked at. I mean, what are those processes, and what kind of risks or risk evaluation is included in those processes? Does the company even have a written process, or is this something that the contracts manager simply goes out and does without any formal process being put in place? The supply chain for most companies is critical, and to what extent are the supply chain terms and conditions reviewed? How often are they reviewed? Is there any understanding of the issues that might have occurred historically that might have to be remedied in redrafting terms and conditions? That is a critical aspect that many businesses don't pursue. Is there a formal project management and conflict awareness training? I mean, does this occur? I mean, how are the contracts people trained? How are the programs people trained? What are they told about how disputes might arise and what they are to do if those disputes arise? Is there a formal process for bringing something to the attention of the law department? Is there a formal process for bringing things to the attention of the finance group? I mean, these are, they seem like very simple things, But in my own experience, I've seen that often issues arise because people really don't understand what they are to do and how they are to react to a dispute situation. And I'm talking here about the early development of a conflict before it becomes a formal dispute in the sense of litigation or arbitration. Is there an ADR process? Does the company recognize that perhaps there are other ways of dealing with the dispute other than litigation and arbitration? For example, is there a mediation process that might be built in to the formal disputes process? Financial controls. I mean, I think we all recognize the issue with having proper financial controls in place. Often it's mandatory, and yet we still have situations where companies go on and are spending large amounts of money on a particular program without there being any real understanding for where that money is being spent and what is occurring to cause cost overruns on a program. Program monitoring and review. I mean, how does that occur in the business? How often do these reviews occur? And are those reviews meant to also highlight the particular conflicts that may have arisen in a particular program? And if they are highlighted, how are they then dealt with? Contract clauses, as we just said, the disputes clause in particular is one that has to deal with the particular situation at hand and shouldn't just be a standard clause that you use over and over again. Is there a contracts review procedure? We had a fairly formal procedure that set out the parameters for negotiating a contract, and if those parameters were exceeded or if they were changed in any way, there was a requirement then for the contracts people to come back to either the law department or to the other pertinent department that might be affected by that clause. So there was a clear instruction to the contracts people when they were negotiating as to where and how they were to deal with changes to the standard form of contract. Contracts management sign-off procedure, again, it seems simple, but often it wasn't clear as to who had authority to sign off on different types of contract changes, or in particular where conflict or dispute arises, who is the person designated to be the person to try to resolve that dispute and make a decision on how to resolve it. Often we come to the end of a contract and there have been issues with it. There may be cost overruns. There may actually be a dispute that has arisen. How often do companies actually go back and do a lessons learned on those contracts? Usually that only happens if there's a real disaster, but it's something that's very useful to do in any type of contract where there have been contractual issues, because it'll flag up for you where you might want to make changes to terms and conditions, for example, or where you might want to make changes in your disputes clause or in the way your supply chain issues are resolved. I mean, these are all very valuable things that come out of lessons learned. And where there is actually a conflict that has arisen, is there a procedure to formally review that conflict and where that conflict is going? There should be, at the outset of any procedure, a formal procedure that is invoked, be it litigation or be it arbitration, there should be a constant review of where there might be possibilities to settle the matter, where you might want to go to mediation to resolve the matter. And that should actually be a formal process that is put in place. So I think what I've tried to say is putting a formal dispute management system in place, something that is formalized, not something that's just done ad hoc, can help both prevent future disputes and can help you to manage current disputes. And there are a whole range of ADR tools that companies can use to try to mitigate a particular situation or to try to manage a particular conflict. I mean, if we can just go to the next slide, I've just put up, of course, some of these are quite obvious, but others are probably less used, but each of them has a role, and I think none is exclusive of the other. I mean, we should always be looking at where we have an opportunity to use any of these along the disputes route. So I think with that, I'm going to stop because I want to make sure the other speakers have time to speak as well, but I think we'll have time for questions later on. Thank you.
Yeah, so our next speaker will be John Lowe. John is an arbitrator, mediator, however, with vast prior experience as in-house counsel, as general counsel. John, I understand you are based in France, in Paris, and John will share his insights on dispute resolution clauses and the experience that companies, that corporates make in emerging markets, in growing market, with making use of these clauses in their contracts. So, John, please go ahead.
Thank you very much, Christopher, and it's a pleasure to be here. Maybe you can go to, does the clicker work or not? Shall we try it again? Oh, okay. Listen, what I want to do here is I'm going to talk about the selection of dispute resolution clauses for contracts and what goes into it or what should go into it. I've often been involved, as Wolf said, often there's not much thinking. I think actually I've seen over the last 10 or 15 years that corporate counsel are starting to think much more seriously about what goes into it and what is involved in making these selections and why you want to argue for one course of action as opposed to the other. We'll get up to the presentation in just a moment. Maybe can we just... What I really want to do is start off by saying, no matter what markets you're dealing in, the company or where the people who are writing the contracts need to know what type of agreements they have. Different dispute resolution clauses may be appropriate for some agreements and not appropriate for others. Big projects, you may want arbitration. Employment contracts, it may be best to use litigation in local courts. Other ways of defining this will be the value of the contract and where it is being implemented. So why don't we go on to the next slide? Again, Wolf just put up a slide showing lots of various dispute resolution alternatives. I'm going to try to make that a bit more simple here, concentrating on litigation, arbitration, and what I will call a tiered dispute resolution process. And essentially what this means, this is a dispute resolution clause, a typical example of which would be the following, where if a dispute arises, there will be negotiations among principals. Sometimes actually the names of the principals or their positions are listed in the contract. If this doesn't work, there may be mediation. We'll get into this a little later. There's an ongoing debate within the in-house community as to whether you should put in a requirement for mediation in the dispute resolution clause itself, or whether you should just leave that as an open possibility. The basic reason for this is that the most appropriate time for mediation may not be actually at the beginning of the contract, where the parties are, shall we say, they're in the period where they're flexing their muscles. They're saying, we are absolutely right, you are absolutely wrong. It's only a bit later on, when the first complaints have been filed, when the responses have been filed, when the companies are starting to be confronted by the reality that this dispute resolution can be expensive, can be long, and yes, maybe the other side does have, we hate to admit it, but they may even have a point. That's when mediation actually may be viewed as a more appropriate, but it's very, very difficult to put that into contractual language. One thing that parties need to consider as a point of departure when deciding what dispute resolution clauses to use is, what do they want out of the process? There are companies that want to drag out the dispute resolution process. The longer, the better. As an in-house counsel, I have been in this position. We had a big dispute in Turkey, which was going on for years and years and years. We had a weak case, so paying 2,000 or 3,000 euros a year in legal fees was perfectly acceptable from our point of view. It was going to be the next general counsel's problem. I didn't really care. So I actually had a case recently where a lawyer in Italy called me up and said, "John, remember that case we were working on in 1999? Could you see if you have some documents?" Tommaso is laughing here. His name is actually Thomas. But this was a Sicilian public works contract, and it was still going on in 2017. Things can go on. But if you want that, it is a perfectly legitimate exercise, and you will choose your dispute resolution clauses based upon that. I've listed a lot of issues that what you might want to look at in determining what is the appropriate. You have to decide what is important for you, whether there is an appeal process or whether there is no appeal process. But there should be some thinking into this before you go into the negotiations with your counterparties, or before you start putting together dispute resolution clauses in your model agreements. Could you go to the next slide, please? Okay, again, somewhat of a summary. You can't get everything with a dispute resolution process. If you choose arbitration, you may not have appeals. You may not get the same discovery in arbitration that you would get in litigation, particularly in jurisdictions such as the United States. So it is a balancing act. Could we go to the next slide, please? Does this work? Okay. Now, what I'm trying to say in this slide is that companies, I've often heard general counsel say, "I'll never do an arbitration again, no more arbitration clauses because we had one bad decision." And I've heard the same thing, "We'll never litigate in the United States because it cost forever and we had a bad decision." The point I want to make here is that no matter what dispute resolution process you choose, there will always be bad decisions. Now, what you have to do is figure out, on average, or what are the possibilities of the various dispute resolution processes, what might happen. In this case, it's good to know what your company's experience it is, so you need to track what happens. And sometimes you're going to find out that litigation may be an appropriate tool for dealing with disputes. But it's good to keep a track record of what happens and what has happened, how much have the cases cost, how long did they go over, what was your assessment of the judgment. So my argument here is know your company's history, know what you're dealing with so that you're working from an informed perspective. My final point, though, is that be aware of that your company's way of doing business may be changing, and you may not have the same data records or records of decisions. So you do have to take account of where your company is going. And my point here at the bottom is intellectual property much more important? How will you go about protecting that intellectual property? And that may be something you will have to take into consideration. When you're dealing with growing markets, emerging markets, I want to point up, oftentimes you may be negotiating contracts and you may be negotiating dispute resolution clauses. So what you put into your model contracts, you may have a beautiful escalation clause, but the other party may not like it. They may say, we want to litigate or have disputes dealt with in local courts. It's always good to have some counter arguments and some data available to give you some support for what you want to do. One of the best sources of information, I don't know if anybody, if the people in this room know about this, but the World Bank puts out an annual study of enforcing contracts around the world. What they do is they look at a standard dispute and then they assess for essentially all the countries around the world how much it would cost to deal with that dispute in local courts. What is the time period for dealing with that dispute? How much it would cost, and what is the quality of the decision? So, by looking at this World Bank study, hopefully I did not put up the link to it, but if you just Google World Bank study on enforcing contracts around the world, you will find that. And again, what I've done here is just pulled almost at random various jurisdictions, looking at the time, the cost as a percentage of the claim. And these are, I think the basic claim was a pretty low value claim, and the quality of the judicial process. And this is, the quality is a bit of a qualitative judgment, but it's based upon practitioners around the world. And what you are going to see here is, just looking at it, litigation takes long. It can be very expensive, with the possible notable exception of the Republic of Korea, although I doubt if you are going to find most companies starting to opt for the Republic of Korea and Korean courts as a forum choice of preference. There are good reasons to do it. Look, it's the highest quality of judicial process, cost of the claim, a 12% cost, and a relatively quick 290-day turnaround time. Other countries are, let's say, not as good. And I like putting these charts up on the screen because oftentimes, I think I'm couple more minutes. Oftentimes, arbitration or other dispute resolution processes are criticized, but it's always a question, if not arbitration, then what else? And it's usually litigation. So it becomes a binary choice, and you have to make choices. Nothing is perfect. What is perhaps more perfect than the others or less disadvantageous? So this is a good piece of information to have. The other piece of information I'm going to raise is look at Transparency International, sort of a corruption process around the world. And I'm going to give you a little war story. Try not to too many war stories, but a few years ago, our finance department paid a bill for a freight forwarder in the Philippines. The value of the merchandise which the freight forwarder was handling was $2 million. The cost of the invoice was about $15,000. They actually sent $2 million instead of $15,000. It was up to the legal department to try to get it back. After 4 years of litigation, including going up to the Supreme Court, we lost. The basic lesson I learned from that is $2 million gave the other side a lot of money to hand out. And there was no other explanation. It was a mistake. The money should have been returned. There was no legal reason why it shouldn't be, but we still lost. So you need to be aware of what is actually happening around the world. And here, again, you can go to Transparency International and look at where countries rank on the scale. But basically, the point is, despite cases of anti-corruption and fraud, there's still a lot of corruption in the world, and the world is a difficult place to do business, and local courts are probably not immune to the pressures of corruptions. I just throw up another couple of studies looking at the efficiency of litigation compared to arbitration. The Council of Europe has been evaluating the court systems in Europe on a regular basis since 2002. They come out with reports every 2 years. The American Arbitration Association, again, I'm growing markets, emerging markets have their difficulties and their problems too. My point here is that the United States, which some of us think to be a relatively sophisticated legal market, still has its problems too. You can see that the district courts, these are federal cases, so again, theoretically, they're handled fairly efficiently by well-qualified judges. They take 3 times as long than an arbitration case. This is your organization, Wolf. These, again, are some examples from the Council of Europe study. So again, Turkey is up there. I didn't put Italy. Yes, I did have Italy in there, Tommaso. Sorry about that. But the number of outstanding cases is just incredible. Okay. There are downsides to litigation. And if you're going into negotiations, though, be aware of what these are, because if you want to advocate for arbitration, you need to be able to put in arguments. I think time is running on, so I am going to stop. These are going to be dealt with later. My own point here is, the only point I'm going to make here is that there have been criticisms of the arbitration process, but arbitration institutions, at least from what I am seeing, are starting to make concerted and real efforts to improve the arbitration process. And I'm not going to get into these. These are tiered dispute resolution things. Mediation I discussed very briefly, but we're probably going to discuss more during the day. And I'm going to stop here and let it go to Deena, I think.
Yeah, thank you so much, John. I think that was quite a comprehensive overview on the clauses which are used and the experience that you then make actually with the actual dispute resolution process. As our next speaker, we have Deena, a legal counsel of Standard Chartered Bank based in Bahrain, and I think the in-house perspective is always very important because first of all, you're the one who has to manage any dispute resolution process. You have to tell your board what's going on, and you have to manage your counsel who are then actually pleading these cases. So Deena, we are very curious to have your experience on that.
Good morning, everyone. This is not good for the vertically challenged. Right. Where's the clip? All right. So, with the enhancement of laws and regulations emphasizing on treating customers fairly and consumers exercising their rights more than ever before to file litigation cases or alternative dispute resolution cases, one can only expect that the volume is going to just increase significantly over time, much to the dismay of in-house counsel everywhere and to the joy of external law firms. In today's litigious business and legal environment, the role and responsibilities of the in-house counsel has intensified in terms of scope, pace, and reporting requirements. In order to have a firm handle on the sheer volume of disputes, legal departments need to focus on enhancing a number of issues, which are the management of external counsel, prevention of disputes, the uncovering of disputes, organization of disputes, post-judgment or post-settlement administration of disputes, as well as reconstruction and reorganization of business, revision of policies or procedures affected by the outcome of disputes, and any further remediation required. I'll briefly be talking about each of these points. So, in terms of management of external counsel, an early step to take in litigation, especially where you are the plaintiff, is to retain counsel to represent you. The attorney process selection process should be done systematically. The quality and skill of your representation can be proportional to success in litigation and the ability to manage litigation and its costs. I would recommend having a panel of firms that companies use, which is what we do. We have around 5 firms that we use per country. We have a regional firm, a panel firm, and then if you're an international organization, a global panel firm. These firms should be selected based on their expertise, capability, let's not forget in this day and age, data security systems, and cost effectiveness. They should be engaged on contractual terms of engagement. I think the days of gentlemen's agreements have long gone. It's important to to strike a fair balance of costs by negotiating early any caps on litigation. This will avoid disputes down the road. Expectations should be documented and communicated with external counsel. And aside from billing, it should be agreed on how often you expect status reports. And I think that's one of the biggest disputes that you enter into between in-house and law firms. And how promptly do you expect turnaround on specific requests? Give external counsel somewhat of a periodic report card, assessing overall performance in categories of costs, results, and service. Share your findings with the counsel and focus on areas needing improvement. That being said, as in-house counsel, we should also be good clients to our law firms, so I would recommend that the reverse is done at the same time. Moving on to prevention of disputes. You can often stop disputes from escalating if you act quickly and are armed with as much information as possible. That being said, even with the best systems and policies in place, disputes cannot be avoided completely. You can prevent litigation or disputes by having a robust system for assessing and escalating complaints and grievances to ensure high-risk ones are not missed and escalated to senior management promptly, and low-risk ones do not become more serious due to a failure to deal with them properly and timely. Make sure that your document management system allows you to identify, recover, and retain all relevant documents without delay. In banking, if you delay a document to a customer by a day or two, that's grounds enough to file a case against you and the case will be accepted. So acting quickly, making sure your documents are easily retrievable is essential. If you operate in a regulated industry with formal reporting obligations, document your obligations and implement systems and processes to ensure that they're actually followed. Analyze potential outcomes and costs before deciding how to respond to a dispute. Investigate the facts. Before making any decision, undertake an assessment of your potential exposure or regulatory action or the value of your claim. Determine what litigation or regulatory action will cost and include an assessment on the downsides. Involve necessary stakeholders and those who can add value as early as possible. This may expand beyond your internal stakeholders to insurers, external legal counsel, or media consultants. Calculate what you consider a realistic settlement value before finalizing your strategy. Be prepared to pay more or accept less than you think the claim or dispute is worth to avoid legal action or regulatory action. Ensuring that management has a realistic assessment of the costs and potential downsides of litigation or regulatory action. You'll find that in a lot of cases, a dispute is simple enough. Just companies don't want to deal with the hassle and the increased workload of what a litigation may offer. So it may be in your best interest just to enter into an out-of-court settlement and avoid that hassle. When documenting a transaction or project, pay close attention to the provisions which create alternative avenues for resolving disputes, such as expert determination or arbitration. This can divert a dispute away from litigation, and, as my peers had said before me, consider mediation as a compulsory first step. In terms of uncovering litigation, it's important that companies have procedures in place detailing how summons and domestic court orders are received and how they are handled thereafter. You should also identify how cross-border court orders are received and handled. Once you've identified that litigation has been filed against you or where you are a plaintiff, it's important to be prepared. This will include ensuring that your witnesses actually agree to be witnesses. We've had a lot of cases where a court will issue a summons for a certain witness to attend, and you assume that they're willing to attend such a session, but at the last minute they'll say, no, I'm not comfortable, I'm not prepared enough, and you have to ask for an adjournment from the court, which obviously makes you look very bad. Prepare witnesses for the types of questions that they will be asked, and if you need a translator to be present, make sure that you apply for this well in advance. I think I've missed a slide. So in terms of organization of litigation, details should be organized in a manner which is accessible to the in-house counsel. The management of litigation can be a cumbersome task, so just to identify specific details on a specific case is mandatory. Maybe it's ideal to have some sort of database that will assist you in retrieval of all the litigation records, and you should always have access to certain details such as case number, plaintiff-defendant details, the date and amount of the claim, whether any provisions have been placed, if so, on what date for your auditor's sake, details of external counsel, legal costs and background of the case, present status of the case. And another issue that you do find is make sure you have a process to get back your original documents from the courts or external counsel. You are under obligations for certain retention periods, and that's another issue, a way that disputes may arise further. So in terms of the post-judgment reconstruction and organization of business policies or processes, when disputes are resolved or litigation has ended, a review should be taken to find out how are you conducting your business? What have we done wrong? What have we done right? Is there a certain pattern or behavior or reoccurring issues which require some sort of remedial action? If there is, consider adjusting your policies and your procedures. Additional training may be required to correct a lack of awareness on recurring risks. You might find something is more of a systematic issue. It affects a number of different organizations within your industry. Escalate such concerns to your regulators. You will find that they may call for a joint meeting between your industry, and effectively better regulations may be put in place to avoid such disputes. Litigation management presents a new set of challenges and responsibility to an in-house generalist already crowded plate. Many learn litigation management through trial by fire, but an understanding of litigation management shortens the learning curve, increases the ability to contribute to the strategic direction of the business, and better balances litigation costs with potential results. Thank you very much.
So, thank you so much, Deena, for sharing your in-house perspective. And as a matter of fact, I think the challenges with dispute resolution, both in litigation and in arbitration, is with the in-house departments and managing the overall process. And that's why I'm so happy that we have as a last speaker Tommaso. Panico, I understand you're legal director of Colt Technologies. So I'm very, very curious from a customer's perspective to hear what you have to say about dispute resolution. We are very happy customers because you provide our global firm with both IP and data services. I could watch in the center of Berlin the Kurfürstendamm being digged up in order to have new cables for your company to be put on the ground, that we have our office equipped. And so, Tommaso, I'm very, very happy to listen to you as a happy customer, to see that whenever there would be a dispute, you would be the one solving it.
Thank you. Thank you, Christopher. I wish all our clients were so happy as you are. My name is Tommaso Panico. I go by Thomas, much easier since I've been in London for 7 years now. And I used to work for an English law firm between Italy and London before. So in my career, I've only worked for 2 employers, if you wish. Some might say I'm a fairly loyal professional. A few of my former girlfriends might have a different view, but I'm Italian, so what do you expect? Jokes aside, my presentation is a bit more jurisdictional specific than my colleagues who have provided institutional approach. Since the theme of our panel is managing disputes in growing markets, or emerging markets, to use an old-fashioned term, I went on the official record, and the growing markets are the famous BRICS: Brazil, Russia, India, China, and now South Africa. Now, I could have picked all of them, but that would not been fair, since I've not have experience in all of them. I wish, but I don't. So I picked the 2 areas where I have the most experience personally, both because Colt has 1/4 of, so 25% of its workforce offshore in India, and 25% of the legal department offshore in India. In my team, I have 11 lawyers. 5 are in London, 4 are in India, 1 is in Amsterdam, and the other 1 is in Dublin, to give you a perspective. So, technology company, as you may know, have a shared services center in India. It's very historical tradition. It's for a number of reasons. It's proving very effective and very good. To have part of the legal department offshore in India is something which is quite different. You might have a legal process outsourcing. You might have an external company providing a service. But my associates who are there are part of the legal team, and that's credit to the former general counsel of Colt, who about 10 years ago started this process, and now we have 15 lawyers in India amongst the 40-something, 45, which we are across the globe. What do I do now? I had the Northern region, I call Technology Services here in London. The company is a former FTSE 250 company, part of the Fidelity Group. After 25 years, Fidelity decided that having a 91% shareholding in a company and keep it in public was not the best solution from a corporate perspective. So the company was taken private 3 years ago, and since then flourished for a number of reasons. It's much more agile. You don't have overheads. The analyst review we have now are from Gartner's and not from Thomson Reuters. And the balance sheet is proving pretty solid with a pretty good growth for a telecoms company, which is quite unusual. You might have read at the Financial Times yesterday, they were not very lenient with British Telecom, maybe even harsh, but that's a representation of the communication market these days. So I'm quite fortunate to be here today to speak. And to go back to why I picked India and South America, again, is where I have the experience, both because I'm a Colt, and beforehand, when I was at Simmons & Simmons, I managed a few disputes in South America. That's why I picked these 2 areas. Now, I had to say that if this organization of the World Litigation Forum will invite me next year in 2 years, I'm sure I will bring China to the table, since my company has just opened a big office there and I would be naive if I expect zero disputes in the next in the next few years. And before I go on with the presentation, I also should say that my dad is a old-fashioned litigator in the southeast of Italy. He goes to court every day, 5-6 hearings, average value 2,000 euros. And after 20-something years, I still have not managed to explain to him what kind of lawyer I am, despite they've taken the same exam. But clearly, if I go to court, or I'm dragged to court by any disputes, in the eyes of my CEO and the CFO, I have not done a good job. So not always a settlement is necessarily a win-win, but that's, in my experience, what I have to aim for. And if sometimes you realize you've been played and you had no other choice, but surely, in my personal experience, settling a case is usually a better option than dragging into an 11 years dispute in Italy or elsewhere. That said, this is an outline, of course. There is no ambition of accuracy, so forgive me if any minor mistakes you will find into the presentation. Please pick them up and file a complaint. I have a few esteemed litigator and mediator who can argue for me. Why did I pick India and Latin America as well, apart from my experience? Also because there is, in both areas, there are slow pace of reforms. They are very large subcontinents, both of them, in terms of population and area. The backlog of cases, on average, is equal only to the Italian ones, and shame on my country. But at least in India and South America is reducing, as opposed to my country. The use of alternate dispute resolution is instead increasing, as we have seen also in John's presentation. And the purpose is to provide an overall of this jurisdiction, an outline. So the Constitution of India dates back to 1950 after the Partition Act, 2 years before, and it contains 444 articles, which is more than the Italian Constitution, and almost as equal as the Italian Civil Procedural Code, which is one of the usual nightmares when you take law school in Italy. But clearly, India is a parliamentary state and a federal state. There is an allocation of powers which is traditional. There is executive power, legislative, and judiciary. Now, the judiciary system in India is quite standard as well, based on the federal constitution. The district courts at the bottom of the chain, high courts, which is second tier, and in every single federal state, the Supreme Court, which is one, as opposed to the US, for instance, there are several Supreme Courts and then the higher one. It sits in Delhi, is established in 1950 after the Constitution was approved, and has jurisdiction over disputes between the central government and the states, same as Italy, for instance, and France, and disputes between different states and territories. There are also a few special tribunals, like the Intellectual Property Appellate Board, Central Administrative Tribunal, as in the UK, and so on and so forth. Now, we go to the alternative dispute resolution for India. In order to tackle the backlog that I was talking before, the Indian Parliament passed the Arbitration and Conciliation Act in 1996. It's quite a long time ago, and that helped in reduce the backlog. The Act effectively introduced 4 forms of different arbitration, or slightly different. The ad hoc arbitration, where no formalities are there to administer, an institutional arbitration with the International Court of Arbitration of the LCIA, which is proving quite effective, and the LCIA has launched an India Center in Delhi 2 or 3 years ago, which actually shows how India is moving into an ADR world. A statutory arbitration, which is mandatory for specific matters, and the parties have no option to abide by the law. And a foreign arbitration, which is a more standard, classic one, proceedings are conducted outside of India, and the award is required to be enforced in India. The foreign award can be enforced on the Geneva Convention or the New York Convention. That said, for arbitration, in terms of conciliation and mediation, very quickly, conciliation has been added by the Act again, and it's been adopted by one of the efficient means of settlement of disputes. It is a non-binding procedure, which is the real problem here, and the neutral conciliator assists the parties to dispute in reaching a mutually agreed settlement. Mediation, instead, was introduced formally in 1999, so slightly after the Act, and introduced the concept of judicial mediation or voluntary mediation. A court can now identify cases where a settlement is possible, formulate the terms, and invite the parties to go into mediation. So effectively, in India, judicial mediation is carried out in the form of a court-annexed mediation. And court-annexed mediation or conciliation centers are now established within several courts in India. Now, this is a sticking point, and whoever has had any dispute in India may know that international law firms in India are effectively not licensed yet. There are some hybrid, like JV, with local law firms, but if you have a serious case in India, then most likely you will have to instruct an international law firm and an Indian law firm, which means it's not going to be cheap. It's definitely going to be long, as John correctly pointed out, and the outcome might be very similar to the Italian case in Sicily that John was talking about. So possibly not recommended, and again, if you can manage to settle, is definitely a better option, or if you can make resort to one of the IDR resolution, even better. That said, about India, we go to South America, other side of the world, but similar problems in terms of backlog, population, and degree of litigiosity of the country. Again, I come from a place where litigating for £200 in district court is completely normal. And I'm not supporting the statement, but if you suggest to find a different way to settle, you are perceived as weak, or you're not a good lawyer, or you don't want to do your job. Of course, how much can you charge for £200 cases? Maybe a couple of candies and a coffee at the bar. But you will be the lawyer of the village, and you are a respectable professional, and you will be highly ranked in the next election for the mayor. And that's how you build your career. That said, in South America, over the last few years, several Latin American countries have amended their domestic legislation to facilitate arbitration. Again, it's a very good movement into the right direction. Arbitration is the preferred dispute resolution method for foreign companies doing business in Latin America still. The local entities and the government remain reluctant to shift to this ADR though. However, specific time frames for arbitration have been implemented across the subcontinent. So if you go slightly more in depth, in Brazil, I have a data which is slightly colliding with what John has, but what I have there is clearly a record, it's not the average. Would be the average for my country. Again, shame on my country. And it's been calculated on a case, it took 2,200 days to finish the first degree. Again, it's not the average, is a record, so apologies for the mistake. The new civil procedure code in Brazil introduced a policy in favor of IDR in order to cut down times and cost, of course. Tribunals are forced to create a judicial center for conciliation and mediation. Again, something quite similar to what the India judiciary is doing. The enforcement of foreign awards can take between 18 and 24 months, which is quite long for an ADR enforcement though. A decision on the recognition of a foreign award can be appealed, and a few changes have been introduced by the recent Arbitration Act of 3 years ago, a principle of pro-arbitration jurisprudence, which is quite of a semi-revolutionary principle in Brazil. Benchmark for best arbitration practices. So we are moving from a country where, again, the courts were seen as the best resort ever to a different perspective. And even the Brazilian government now is entitled and encouraged to enter into arbitration agreement, whilst before that they were definitely discouraged. If we move to Argentina, in Argentina, a mediation process prior to the beginning of litigation is mandated by law. Again, another principle we have seen. The mediation is carried out by a licensed mediator, and the procedure is confidential and not subject to formalities. Arbitration is regulated by the Civil and Commercial Code and follows a few principles which are recognized across the globe. Principle of competence. I'm not going to go into academic discussion here, but I'm sure that you will know this. The obligation for the arbitrator to be independent, so disclose any matter or recuse himself if he finds inappropriate to decide on a case. The exclusion of the judicial jurisdiction when an arbitration agreement exists is pretty crucial, and the power of the ordinary tribunal still to issue interim measures, but only the interim measures. The parties cannot waive their right to challenge an award in court when such award is contrary to a mandatory legal provision. And the last point is maybe the most important one. When there is a risk for public policy, then a public entity, i.e. the government, cannot resort to arbitration. And this, unfortunately, has been used to avoid arbitration a few times. So there's been a caveat has been inserted in the law, which possibly is used in a way which is not supposed to. Chile, famous for a very good wine, as you may know, but also because it's supposed to be in South America, and no disrespect for the other countries, the most advanced or westernized part of the continent. However, the Chilean legal system does not provide for settlement via ombudsman or the other kind of mechanism that Wolf listed at the beginning. And mediation, for whatever reason, is not commonly used. The settlement agreement reached in mediation do not need to be sanctioned by the court. However, since arbitrators have no authority to enforce an award, the assistance of the local court is needed. That's maybe why mediation is not commonly used. And then there is a difference between domestic commercial arbitration and international commercial arbitration. At local level, the courts have recognized the agreed principle, competence, again. The awards are easy to challenge, but they are treated as judgment issued by a court, and thus they can be reviewed on the merits. So you risk to have another endless dispute going forward. On international commercial arbitration instead, this follows principle of modern arbitration, standard, classic. Party autonomy, the autonomy of the party is preserved, the flexibility of the procedure and the intervention of the court is very limited. The institutional arbitration developed thanks to the Center of Arbitration in Santiago has definitely developed the practice in Chile and is proving quite effective as opposed to its neighbors' countries. An international arbitration award cannot be appealed. Again, this applies only to international commercial arbitration. And I don't think I have anything else, so I would like to thank you all for the attention and to the organization.
Thank you very much. I mean, the impressive result is that we kept to the timetable on the minute, so that's always good to have a German timekeeper around. Now, I don't know if there are any pressing or immediate question to one of the panelists. Otherwise, I would suggest that we go to the network coffee break. Thank you very much.